My name is Esther Whitner, and this is the second property tax workshop that I've been part of hosting for residents of Jersey City. I'm doing this in conjunction with some very wonderful organizations that I have the pleasure to work with. The first one is the Jersey City Homelessness Advocacy Group, and we are lucky to have one of the members of the group here, Ms. Renee Torella. And one of the things that the group recognizes is that homelessness is a very broad issue and is not just contained to people that we might think of normally as people who are living on the streets, but it does expand to people who might be one paycheck away from making their rent payment or their mortgage payments. So we felt that part of what we do would be to help people learn how they can hopefully save some money on their property taxes and help, because every penny does count in these difficult economic times. I'm also doing this with the JCPAC, the Jersey City Political Action Committee, and I do that with Ms. Yvonne Balser and some other residents of Jersey City, and our focus is to help keep Jersey City affordable and for the betterment of Jersey City. So this is some of the work that we do. Ms. Yvonne Balser, who's here taking footage, also has a television show called Speak NJ that plays on Monday and Tuesday evening on Channel 51. So this evening we're fortunate to have Mr. Tom Olson and Mr. Corey Kessner of McCurdy and Riskin, a leading real estate attorney in the state of New Jersey, who's actually a homegrown Jersey City person who's come back as part of his community service to help residents of Jersey City learn about what a property tax appeal is and to help teach you how to file your own property tax appeal and to empower you. So with that being said, thank you all for coming, and I turn it over to Mr. Olson.
Good evening, everyone. I want to thank Esther and Jim for inviting us here to speak to you this evening and for all their hard work. As Esther mentioned, I'm an attorney. Seated on my right is one of the other attorneys in our office, Corey Kessner. We're with the firm of McCurdy and Riskin. We're located in Morristown, New Jersey. We specialize in real property tax appeals and eminent domain matters. And I've personally been doing real property tax appeals now for 30 years. Corey has been with us for a while now as well. We've had extensive experience throughout the state, including Jersey City. Right now, property tax and property tax appeals are a hot topic. Given our current hard economic times, property tax can be a big burden on property owners, particularly homeowners. One of the only ways, really, that municipalities can raise money is through property taxes. That's the main engine that they have to raise revenue in order to pay for the things that they need in their budget. However, it is something that you as property owners can do something about if, in fact, your property assessment is incorrect. Your taxes are based on two components. One is the tax rate, and the other is your tax assessment. And the tax assessment is set by the assessor, and then the tax rate is set by the municipal council in the budgeting process. At the beginning of each year, budgetary year, the municipality has a finite amount of money that they need to raise for their budget, and they look at the assessments, and then that will determine the rate based on what it is that they have to raise. There really isn't anything that we can do about the rate. However, we can give you some guidance with respect to what you can do with respect to your assessment if in fact it's incorrect. I did give you a handout. We can go through that really quick, and I'll give you a little bit of the guidance as to how tax appeals work. Because while you do have the right to do something about your property taxes, it is also an area of the law that's highly technical. There are a lot of requirements that you have to meet along the way. There are a lot of pitfalls along the way, and even though you may be entitled to a reduction in your property taxes, you may not actually obtain it in a particular year because you fall into one of these pitfalls along the way by not meeting some of the deadlines or doing something else that you're supposed to do. All right, so first things first, analyzing your assessment. In a town that's had a revaluation, when I say revaluation, where they've actually just reassessed everybody and they're at 100%, If you look at your assessment, it's pretty easy to figure out what the municipality is saying your property is worth. If you're assessed at $1 million in a revaluation year, the town's saying you're worth $1 million. And that's what they're saying your property would be worth as of the assessing date. All property in the state of New Jersey is assessed at fair market value, which is what it would sell for between a willing buyer and a willing seller, as of October 1st of the pre-tax year. What does that mean? Well, it means for 2013, which is the year now that we're in, the value date is October 1st of 2012. That's the date that the property value will be determined as of. Now, in Jersey City, there has not been a revaluation in about 25 years, I think. It's been a while. So you may look at your assessment and you may say, okay, well, my property is worth $500,000, but it's assessed at $300,000, so I guess I really don't have an appeal. I guess I'm okay. Well, what happens is as time passes from the time a revaluation is done, and as the years go by, that 100% ratio to true value starts to slip. Because when the market is rising and you get these fluctuations, you may be assessed at $1 million, but if the property then sells 5 years later because the market's gone up and it sells for $2 million, well, now it's not assessed at 100% of value anymore. Now it's assessed at 50% of its value. So what happens is every year the assessor is given copies of all of the sales that take place in the given municipality during that year, throws out the bad ones. When I say the bad ones, they're some that are considered non-usable. Sales between father and daughter, husband and wife, those aren't really good sales, so those are thrown out. But the good sales, the sales that were listed with brokers and that took place between willing buyers and willing sellers, those are collected and they're sent down to the Division of Taxation down in Trenton. They're plugged into a formula, and every year the state publishes what's called a Chapter 123 ratio for that municipality. They're published online now. They put out a little book like this that you can print off. And each municipality has its own ratio. For 2013, the ratio in Jersey City is 32.72%. So it's not 100%. It hasn't been 100% now for a while because it's been a while since the last revaluation. So what that means is if you take your assessment, and if the assessment is $100,000 and you divide it by 32.72%, that really says that the city is, or that assessment indicates a value of $305,600 in round numbers. Okay. Now the law is a little more complicated. The law recognizes that the assessor can't get it exactly right. He's not going to get everybody at 32.72%. Just it's impossible. So he's allowed what's called a 15% corridor, up or down from that number. So the upper limit, if you take 32.72% and take 15% above that, that gives you 37.63%. So if you go back to my example of a $100,000 assessment and you divide it by the upper limit of 37.63%, which is what the upper limit in Jersey City is in 2013, that means you would have to show your property is worth less than $265,745 in order to be entitled to a reduction or relief. That's just doing the math, 100,000 divided by the upper limit. So if you look at your assessment, you divide it by the upper limit of 37.63%. That is the number that that is the value that you have to show less than in order to be able to get relief from your property taxes. Now I mentioned it's 15% up or down on either side. The lower limit, 32.72 minus 15% is 27.81%. So if you take the $100,000 and divide it by the 27.81%, that's $359,600. If the municipality, you go to, I know, I'm confusing you with all this math. But what the long and the short of it is if the municipality goes and proves your property's worth more than $359,600, then they can raise it. It's rare, but it is possible that it can be it is possible that your assessment can be raised if in fact its value is more than what that lower limit of the ratio is. If it falls in between, the ratio and the upper limit, or the ratio and the lower limit, it won't be raised and it won't be lowered. It'll remain what it is. But if it falls outside of either of those corridors, up or down, then it can be changed. It will be changed by the County Board of Appeal. And what you're most concerned with if you want to reduce your taxes is, okay, do I fall outside that upper limit? And if I do, then there is a problem with my assessment, and I should do something about it, because you shouldn't pay more property tax than you should, than your fair share. So that's again, I know I confused you a little bit with a lot of math there, but that's, especially in Jersey City, where there's a low ratio, it's something you have to be aware of. So that's Chapter 123. Now, Chapter 123 does not apply when there's been a general revaluation or reassessment in a municipality. Then everybody's at 100%. Jersey City has been taking steps toward doing a revaluation. The current information that I have, although this is subject to change, is that the revaluation will now be placed on the books for the 2014 tax year. So it's just 1 year from now. Although that's subject, again, to change. I think it's been delayed already 1 or 2 years, and it's always possible to be delayed again. But if it goes forward, whether it's 2014 or 2015, whenever it's put on the books, all that ratio example I just gave you is out the window. You'll be getting notice of your new assessment whenever the revaluation, if it goes on for 2014, towards the end of this year, you're going to get letters. Letters are going to say, here's what your new value is. And that's 100%. So if they say it's $350,000 assessment, they're saying that's what it's worth. Okay, so we'll have to see as the year progresses whether they put it on for next year or not. And if they don't, then there's going to be a ratio again for next year, and you can look online and see what the ratio is for 2014. Okay, and okay, now filing deadlines. What do you decide? Okay, well, I want to do something with about my property tax assessment. Well, the books are closed by the assessor usually sometime around January 10. Right? Before that time, you are always free to go see the assessor before that, and the assessor has the ability, if they deem fit, to change the assessment without even filing an appeal. Jersey City does have a very good professional assessing office and a good professional assessing staff, and you can go see the assessor in October, November, and say, you know, I see my assessment here, and this is how the numbers work out. I really think that right. And, I'm sure the assessor would be willing to talk. Now, if the assessor looks at that and decides that the assessment shouldn't be changed, right, so now what do? You get your notice, and you're going to probably just start getting your notices now. They come out right around February 1st. You get little postcards with the assessment.
Well, I got Bayonne.
You got it? Bayonne got it? Okay, you're from Bayonne, and you've got yours already. Okay, so you got your cards, and you say, wow, something's not right here. I'm just too high. What should I do? Right, you can file an appeal. To have that heard, the value heard by a competent either board or the court. The deadline, unless it's a revaluation year, is April 1st. And this year, April 1st is a Monday. This year, April 1st is the Monday after Easter. So Easter Sunday is March 31st. But that's the deadline. So you can file an appeal. I did provide copies of the appeal form. I think most of you have, if not, they're up on the table. You go and you file your appeal. If the property is assessed at $1 million, and that's the assessed value now, not the doing all those numbers I gave you, but the assessment. If the assessment is $1 million or less, you must file your appeal with the Hudson County Board of Taxation if your property is in Hudson County. If you're in another county, you got to file it with that county. But here in Jersey City, you would file it with the Hudson County Board of Taxation. And it has to be filed by April 1st. Period. There's no exception. If you mail it out on March 29th, and the mail being what it is, it gets there on April 2nd, too bad. You have to wait till next year. It's too bad. So it has to be there by close of business at the county board by April, the end of business on April 1st. If it's assessed at $1 million and $1 or more, so $1 million and $1 or more, you have the option. You can either go to the county board or you can file directly with the tax court. Most residential properties in Jersey City are not going to be assessed at more than $1 million given the low ratio. So you're almost certainly going to go to the County Board of Taxation. Filing fees at the county boards are done on a sliding scale basis based on the amount of your assessment. And again, in the forms I gave you, that's on the second page. But it depends again on the assessment. It's $5, $25, $100, $150, depending on how high your assessment is. So you go and you file that with the local County Board of Taxation. By the way, there is one exception. There is an exception to the April 1 date, and that's what the town does a revaluation. So if Jersey City does a revaluation next year or the year after, the deadline is May 1st for towns that do revaluations. They've extended that a little bit to give the towns a little more leeway when they're doing that. It's a big job to do reassessments and do revaluations, and it's also important for you as the property owners to have a little bit more time to analyze those. Okay, so then you file them at the county board, and you have to do it by April 1st. Once you file that appeal, you will eventually get a hearing date from the County Board of Taxation. They will mail you a notice, and they'll say that your hearing will be scheduled for June 10th. Come in at 9 o'clock or 10 o'clock, whatever time, and you go to that county board. Prior thereto, at least a week prior thereto, if you're going to have any evidence that you want to submit, whether it be comparable sales or whatever, at the time you file your petition of appeal, you can put them on there. There's a little area on that. You can put your comparable sales. If you haven't done it at the time you filed your petition, you can still get it in. You submit it to the county board and to the assessor. The rules would say you have to do it at least a week before. In writing, submit it to the assessor, submit it to the county board, and then you can go and testify as to the sales. You have to be very careful with the sales that you use. Again, the sales have to be what's called arm's length sales, or usable sales in tax assessing jargon. Because there are many sales out there, especially today, given the foreclosures and the short sales, that aren't necessarily considered to be good proof or good comparables. The best example of a good comparable would be Joe Smith selling to John Doe. Joe Smith listed with a broker. John Doe comes in, has no relation to Joe Smith. He looks around. He says, "Okay, you want $1 million? I'll pay you $750." They agree on $900,000, and then the sale then takes place. That's a good sale. It's an arm's length sale. It was listed with a broker. There's no problems. Joe Smith didn't have the mortgage company about to foreclose on him, and he didn't have a lot of liens on the property. It was a good sale. What we're seeing more and more of are what's called short sales or sales in lieu of foreclosure, where people are selling properties at very low prices because they have no other choice. If they don't do that, they're going to lose the property altogether. The assessors will look at these sales. Remember at the beginning of my talk, I started to mention that the assessor gets the deeds on all the properties. Well, he's supposed to look at those and investigate them and decide which ones are good, which ones are bad. The short sales or sales that is made under duress are one of the categories that are considered not usable sales or bad sales. And so he'll make a little notation on that, and it'll be flagged as a sale that's not usable. And if you tried to use it as a comp, it most likely would not be considered by the board, by the county board, or eventually if you went to tax court. It doesn't automatically knock that sale out, but it's very difficult unless you could show that it really was sold arm's length, even though it was a short sale. But it's not easy to do that. Right? So you have to be careful with the sales. Estate sales are another good example of sales that are usually not considered to be good comparables, because oftentimes people, when they pass away, their estates will sell them, and they really want to sell them quickly, and they're not considered good sales. Now, that maybe is a little easier to show that it was arm's length, because a lot of times the estate isn't in a hurry. The estate will list it with a broker. They'll have it appraised, listed with a broker, and it'll be on the market like any other property, and there'll be negotiations back and forth. So if you could show that, then it doesn't automatically knock it out. Yes, sir?
So how does one find these comps if you don't have a real estate professional with access to all the listings and the details of a closing?
There are some sources out there. One is I know that I'm going to give you a website because this is there's a website out there, www.njactb.org. Okay, that stands for New Jersey Association of County Boards, County Tax Boards. And on there, you will be able to surf through there. You'll be able to see your assessment. You actually can see the assessments of every property that's in that municipality. And if there was a sale of that property that took place, that's usually listed. You can also, there are search engines that you can use in there to. Well, if the sale's listed, sometimes the code will be there. There'll be a code. If you see a 26 or a 10 or a 13, that means the assessor flagged it as a non-usable sale. And when you go on that website, there is a link. You can print off the non-usable categories. Okay, so that'll give you some information. But so that's one source. It's not necessarily that easy. You may have to try and do some digging. You can go. There are links to some other websites. You can get copies of deeds. The website I just gave you at least give you a start. It'll give you the book and page where the deeds were recorded. So you can either go to the Hudson County Hall of Records and get that, or there's some websites that will allow you to get that. Get a copy of the deed. Call, try and see if you can reach out. There's usually a lawyer listed on the deed, and lawyers are easy to find on directories today. You can call one of the lawyers, find out, hey, was this a good sale? Sometimes you have to do a little legwork, but what's available today online does give you a good source to start to look for information. But again, you should try at least to make some effort to ensure that your comps are good. Yes?
Hi, could you repeat that website again?
Yes, it's www. And I'll give you its letters, njactb.org.
Okay.
Okay? Repeat again. It's free. It's a public website. It's done by all of the county boards in the state of New Jersey, and they compile this information and make it available for you as citizens of the state.
And
Yes?
does it, in my area, it looks like a lot of companies, corporations are buying properties now. Does it matter whether an individual is buying it or a corporation?
If it was a good sale, it shouldn't make any difference.
Okay.
That may be a flag, though, that maybe they're picking up distressed properties. So, and again, you have to look and see if the assessor considered them usable or not. Another source of information, you can go to the assessor's office, and he has it's called an SR1A form, where every sale that takes place in that municipality gets this SR1A form, and the assessor will write down on that the particulars of the sale and whether or not he felt it was a good sale or not a good sale. So that's another, and those are hard copies. That's another source.
Okay. How recent do the sales need to be? Like within the last 6 months, year?
Good question. How recent should the sales be? They should be as close to that October 1st value date as possible. For 2013, your value date's October 1 of 2012. So they should be as close to October 1 of 2012 as possible. Most county boards don't like to see sales that are more than a year old. A lot of them don't like to see sales that take place after October 1 of 2012. We will argue, though, that a sale is January of 2013. It's not that far off. Probably was negotiated before October 1st or right around October 1st. But the county boards really like them to be as close to October 1 as possible, and not much past October 1 if possible.
If I have a relatively fresh professional appraisal, am I good to go?
Okay, good. That's another good question, and because we see this a lot. You have an appraisal. Maybe that appraisal was done for refinancing. Maybe the appraisal was done as part of your sale. Maybe you got a mortgage when you bought the property and you got an appraisal. You refinanced. That information, the information there is helpful. Certainly you can look at the comps the appraiser used and see if those are good. And you certainly can supply the assessor with a copy of that. But that in and of itself is not going to be satisfactory proof when you go to your hearing. You cannot go to the hearing and submit just the appraisal, okay? You have to have the appraiser with you to testify because the other side has to have the right to cross-examine the appraiser. Oftentimes that appraisal is not done as of the right date. You remember the value date is October 1. Maybe the appraisal was done in August. Well, again, as a talking point or as a source of information, that's good because it's close to the assessing date. It's something that you can discuss with the assessor, or it's something that you can use to maybe the comps from. But it's not going to be good on the day of the hearing. You've got to have an appraisal done as of the value date. You've got to bring the appraiser in with you. Yes, sir.
We're talking about sales, but in certain areas there's units for sale for like 2 or 3 years because of the economy. They don't buy them. Does the market or the offer on the price they're offering the properties have anything that can be used?
I would
like
say
in the
that
area, the average asking price is
Right.
because of the economy.
at the county board, it's something you might want to bring out. I know that in and of itself, offers or even contracts that don't get closed on for whatever reason aren't really admissible as proof. But I think it's something that you can bring out and say, look, I don't really have a lot of comparable sales because there haven't been any really been any in this particular area. This is what the current listings are, and nobody's able to move them because of the market.
Yes. I just purchased a home this past October. When you talk about the tax year, it would be, if it was, last year was 2012, so the tax year would be 2011?
No, actually that's probably the best evidence of what it's worth for this year. October 1st of 2012 is the assessing date for 2013. You want to have sales as close to October 1st of 2012 as you can get. So if you just bought it, that's perfect.
I have a question. If you're in a redevelopment area, does that affect your sale price? Can you use properties within a redevelopment area?
You can, if those sales are otherwise good in a redevelopment area, I don't see why you couldn't use them. Sometimes, though, if you're in a redevelopment area, it becomes difficult to sell your property because eventually, some people don't want to buy in a redevelopment area because maybe the redevelopment's about to start, and those properties then are going to be acquired for the redevelopment project. Sometimes you're in a redevelopment area and you can't do anything with the property because the zoning is now the redevelopment zoning, and the local municipality doesn't want you to do anything because it's going to be redeveloped as a big project. So now people may not want to buy them in a redevelopment area because, well, we're going to get
So can you appeal because you're in a redevelopment area that you lost value?
If the sales in that area show that the values have declined, yeah, I think those would be sales that you could use.
If we were going to try to do this on our own, step by step, what that hearing is like in this, because I'm not really seeing it in paper, you want to talk us through that?
Well, okay, yeah, let's keep going. Now, you filed your notice of appeal and your petition. You've given in the comps, whether you put them on the petition or you gave them in beforehand. And now is the day of the hearing. There are many, many appeals filed in a city like Jersey City. It's a big city, there's a lot of appeals. The county boards have only so much time to actually hear them. So you will get notice of a hearing, and there may be several hundred appeals on that day, right, Gordon? Yes. So when your case is called, and you know, they try and do it in staggered times, but you may be called in at 9 o'clock or 10 o'clock, and there may be 30 or 40 other cases on it in that same little time period. So you'll be called up, and you'll give your testimony, what you think it should be, and you'll talk about your comps, and then the city will do its presentation. And they have the right to cross-examine you. The attorney can cross-examine you, and you can also ask questions of the city's witnesses. But you don't get, you're not going to have all day to do it. It's probably only going to be 10 to 15 minutes of a presentation. Now, there are exceptions to that, but it's probably just that little chunk of time that you're going to have to present your case. So you want to be prepared. You want to be able to discuss concisely and cogently what you feel it should be. They will then hear the case. They'll say, thank you very much. You will hear from us. Okay? And then what you will get is you will get in the mail their judgment. It'll be a little blue piece of paper, and that little piece, that judgment will show you what your assessment originally was, and will show you what the judgment is, what their verdict is. Well, there is another level that you can appeal to, and that's the tax court. The state of New Jersey has a tax court that's set up. It is a court that's staffed with judges, judicial judges who are in a courtroom like any other judge. Again, there are time limits that go with filing an appeal from that. You get your judgment in the mail. You must file that appeal with the tax court within 45 days of the date that it was mailed out. At the bottom of the form, it'll say date mailed. And then I say it was mailed out on July 15th. Well, you have 45 days from July 15th to file a complaint with the tax court and ask that the tax court hear the case. If you get it there the 46th day, you're out of luck. You gotta wait till the following year. Okay, and then that judgment becomes final.